The Cumberland County Sobriety Court was established in 2010 to address the number of high-risk defendants charged with alcohol-related offenses in our community. Chief District Court Judge Elizabeth Keever explains how this program operates as a treatment court for individuals who have multiple DWIs pending at any given time and those who have prior convictions. This court program is helping to create a safe community and is an excellent example of smart justice.
Sobriety Court is a court that we established in 2010 with a grant from the Mental Health Center. It's designed as what we call a treatment court, which means that we have individuals who have substance abuse issues, alcohol generally in this case, who have been convicted of driving while impaired and have prior history of driving while impaired. So they are the highest level of punishment that is available to us. And Sobriety Court simply makes sure that they remain sober during the period of their probation. That's one side of Sobriety Court. The other side of Sobriety Court, as we worked into the treatment portion of it, we recognize that there are a significant number of individuals in Cumberland County who have more than one driving while impaired charge pending at any one time, which is simply a red flag. I mean, obviously, once you get a driving while impaired charge, if you get another one, that indicates you have a significant alcohol issue. So we also monitor folks pre-trial who have more than one pending driving while impaired charge at any given time. And we monitor them pre-trial by making sure that they have a curfew, that they are monitored with regard to alcohol and drugs during that period of time. There were about 63,000 persons charged in the state of North Carolina in the last fiscal year, 2,000 of those in Cumberland County. About 108 folks died as a result of alcohol-related offenses in the state of North Carolina, about 10,000 across the country last year. So it remains a significant issue, and what results from drunk driving can be catastrophic. An individual is arrested for driving while impaired. They go before a magistrate at the detention center. The magistrate checks the records, and if they have a pending DWI, or now we're actually picking people who have had a DWI conviction within the last 3 years. If the magistrate sees that, then they are given a court date for Sobriety Court. They come to the immediately next Sobriety Court, and they are advised that they are now part of Sobriety Court. They are drug tested at that point in time. They are used an Alka-Sensor that they can determine whether or not they're using alcohol at that point in time. They're given a curfew. They're given information about how to sign up for the continuous alcohol monitoring, and then every 2 weeks they come back in until they dispose of their case. Citizens are used to the concept of the ankle bracelet now. Lindsay Lohan wears an ankle bracelet. Other people wear ankle bracelets. This is an ankle bracelet that's a little bit different. Those take where you are at a given point in time. These monitor your use of alcohol. They measure through the sweat whether or not you have consumed any alcohol. So these individuals are placed on continuous alcohol monitoring and are monitored, and if they are found to have used alcohol, then basically they have violated their conditions of pretrial release, they're violated their conditions of probation, and an order for arrest can be issued and they can be arrested for that violation. The fascinating thing about this is that in the time that we have started using the continuous alcohol monitoring, we've had very few people who have violated. It's something about knowing that someone is monitoring you, that if you violate, you can be arrested. So we have found that the use of the alcohol monitor, which the defendants pay for, that's not paid for by the state or the county. The defendants pay the cost of having that monitoring system in place. And they recognize the need for it, and they are not drinking alcohol. And if you think about it, most of these people who are chronic alcoholics, chronic users of alcohol, it's $12 a day for the monitor. It's about what many of them were spending on alcohol over a given week that they're now spending to not use alcohol. If an individual from Harnett County or Bladen County is picked up in Cumberland County, they don't come into Sobriety Court because we're using Cumberland County money to do this, and so we just do residents of Cumberland County. So we've had 31 come through the treatment portion. That is, they've been convicted, they're on probation, and they come in. And so far we've had 9 of those individuals graduate, which means that they have been successful in completing the program. And the program lasts for at minimum of 12 months. So they've been in the program at least 12 months. They've complied with the curfew. They've not tested positive for drugs or alcohol. They've attended AA or NA. They've been through treatment, and they have graduated. None of our graduates have reoffended. And so we still have some folks in the process. Now, we've had some folks that were placed on who have tested positive and have gone off to serve their jail sentence, basically, because they could not survive. The research tells us that even those folks who don't graduate, if they can get through 6 months of the program, they are much less likely to reoffend, even if they don't successfully graduate. We've had 261 folks come through the pretrial program. Many of those have ended up, have completed, been convicted, or some of them have been not convicted. They've been found not guilty of that offense. But we've only had, while they were actually in the program, 2 people who've gotten new charges while they were actually in the program. And when you think about 260 people had multiple cases pending, it's clear that they have an issue and that this program has made a difference in the fact that they have not reoffended during that period of time. We currently have a number of other treatment programs. We currently have an adult drug court program for individuals who have been convicted of felonies, have a substance abuse problem. Most of theirs is cocaine, although we do have marijuana and heroin as part of that. We have a family drug treatment court, and that's for individuals who are involved with the Department of Social Services, have petitions filed because they've abused or neglected their children, and it's a direct relation to the fact that they have a substance abuse problem. So we're working with them so that they can get clean and sober and have their children returned to them. And then we're hoping to start a veterans court for individuals who are veterans and who have substance abuse and mental health problems and are involved with the court system. We're hoping to start that within the next year. We've been working on that now for over a year, and it's just a matter of finding the right grant so that we can hire someone to work that program for us. One thing we want people to understand is it is a crime to drive under the influence of alcohol or controlled substances. Right now it's a .08. That's 3 or 4 beers for most people who drink. People at .05, which is not a crime, but probably is believed as the most dangerous time because those are the folks who think they're okay. So what we want to say to folks is, if you're going to drink, find somebody else to drive, because you don't know what effect that's going to have on you, how it's going to affect your response time to things. And we need to stop people from drinking and driving, and that's the end. And that's what we're trying to do with these courts, is to help people solve that problem of substance abuse. So we are very proud of our courts, very proud of my judges, Judge Tucker and Judge King and Judge Pone, who actually sit in these courts and work with these individuals, and Judge Franks, who's working towards our Veterans Court. They're making a difference in the lives of people in Cumberland County.